Please be seated. Thank you. This is the time set for oral argument in Founding Fathers versus the Arizona State Board of Charter Schools. Our cause number 1CACV 150664. Let's begin with introductions of counsel.
Ms. Condis for the School of Founding Fathers.
Thank you very much.
Tim Anderson, Assistant Attorney General for the Arizona State Board for Charter Schools.
Thank you very much. Let me go through a few preliminaries. Each side, of course, has 20 minutes. The appellant may reserve time for rebuttal. When you go to the podium, if you would if you plan on reserving some time for rebuttal, let us know what your best estimate is of that time, then we'll make sure, or we'll try not to poach on it so that you actually end up with that rebuttal time. Let me advise the parties and counsel that we have closely reviewed your briefing on appeal. We have reviewed pertinent portions of the record, and so we're quite familiar with the issues and the facts and your arguments today. You might wish to take that into account in your remarks today. We are recording the proceedings today, both video and audio, and so when you go to the lectern, if you could please restate your name. That way whoever wants to watch this or hear this will be able to figure out who's speaking. The video will be up on our website in a few days, and also it is available in a few days on YouTube. So with that, let's go ahead and begin.
May it please the Court, my name is Leonidas Condis, and I'm representing Founding Fathers, which is a charter school that is appealing an adverse decision from the Arizona State Board for Charter Schools. This particular matter is an appeal basically based upon the improper revocation of Founding Fathers based on the fact that we believe that it was contrary to law, contrary to the relevant statutes, also contrary to certain specific findings of fact and some of the evidence that was present at the trial. Charter schools were started in 1994. At that time, the legislature decided to join 10 other states to authorize charter schools in the state of Arizona. In that, they created the charter schools with a primary purpose that's found in 15181. The purposes basically set out 3 points. One is that it would provide, the new school would provide a learning environment which provides pupil achievement, an increase in pupil abilities. 2, that it would improve pupil achievement as part of that learning environment. It would serve as an alternative to traditional public schools, and it would be a school that would allow the parents and the children to have a choice as to where they would want to go to school. With that, they also created the structure of the charter schools. At that time, I think there was about a 3/4 page of actual charter school law. It's now gone into, I think, the 3rd page now considerably since the last 20 years. It has grown, and new additions have been added based upon what they find as they go forward. The Charter School Board initially was one of a number of charter school sponsors. That included the Department of Education and included all the districts in the state of Arizona. As time has gone on now, charter schools and the Charter School Board is probably the only real issuer of charter schools, and the others, almost all the charters are now under the umbrella of the Arizona State Board for Charter Schools. They were given their power under Section 182, which established that they would be responsible to have general supervision over the charter schools. They were to adopt their own rules for their government. They were to adopt their own policies of the board and work undertaken by it. That's one of the areas that we believe that the State Board either incorrectly interpreted or intentionally misinterpreted with respect to the operation. In 182.7, F7, it has the allegation, no, I'm sorry, it's not, yeah, 182 F7. It says that the board can create their own policies, but it mandates the delegation of those policies, the enforcement of those policies, to the school superintendent of the state. And that's a logical interpretation of the educational law as has been in the state, because the Constitution provides that the superintendent of public instruction is the head of the educational system. Only in this one area, primarily, the area of educational ranking or typing, and I forgot, I just remembered, I want to reserve 5 minutes. Okay. It delegates to the superintendent because it has the staff, the ability, the department to check out, supervise, and hold to the standard on just about all the educational requirements in the statute, both state and federal. The only
Mr. Condos, let me ask
Sure.
a basic question here. What is at issue here is the board's decision to revoke the charter. How is that a policy? I mean, assume for the moment I agree with the argument you've just made then. How is the decision to revoke a charter basically the execution of a policy?
Because it was the main criteria that they used in the revocation. In other words, they created a policy which was mandated by statute that they had to create, I believe it was 182E, that they were obligated to create some sort of performance framework so that this wouldn't happen. So there'd be some guideline in looking at the scores, and we wouldn't have, since we have now almost over 500 schools, there wouldn't be different criteria applying to all the schools. Unfortunately, the way they created it, it relies on the test, initially the Ames test, and I'm sure the court knows that it's been in abeyance for the last 3 years because they've instituted a new test and are coming up, no longer have the A through F, but are coming up with new standings. So this is kind of the only school that's going to be before you. And the delegation part to the state goes hand in hand with ARS Section 241. 241 is kind of, it established the A through F standings, but it also provided remedial effort in that.
But let me get back to Judge Norris's question, because your allegation in this appeal is that the board did not have the statutory authority to revoke the charter, and I'm having difficulty with that on a couple of levels. Let's assume, for the sake of argument, although I'm not sure I agree with you, that a decision to revoke is a board policy. But then you have a specific statute, way more specific than this general delegation statute you're relying on, that specifically gives the sponsor the ability to revoke a charter at any time if the sponsor determines a charter holder has failed to do any of the following. And so that's a specific statutory authorization to revoke the charter, which, as we know, just general case law, the specific governs over the general. And so how do you get around that statute that clearly gave them the authority to revoke?
They do have the authority to revoke. It's the basis of the revocation.
So you're conceding they had the statutory power to revoke, notwithstanding what you say in the opening brief?
No, they're given the statutory authority to revoke by statute. The question then becomes, what are the reasons and what is the basis that gives them that statutory power to revoke? They utilize the test, and solely the test, to apply to the 3 criteria as to why a revocation should occur.
Okay, but I just want to make sure, because I don't think that's what you say in the opening brief. You're conceding that they had the statutory authorization to revoke your client's charter. You just disagree with how they got to that decision.
The statute does give them the right to revoke. All right. And the problem is that to get to the right to revoke, you have to look at the charter as a whole, the charter contract, et cetera. And the charters and the charter schools were not created just solely to see if they satisfy a test. And in this particular school, it's extremely difficult. The school founding fathers itself is a unique school for all practical purposes as a charter school. Through the last 5-6 years, it's switched from a achieving school to a non-achieving school, and the bulk of that has been because of the influx of students that the school has to take under the law who are special education, who are coming into that school from the districts 2 to 8 years or more behind the grade. And then what happens is that the abuse part on behalf of the state board is they look at these schools where this school takes them. If an 8th grader comes in at a 3rd grade level reading, it would be silly from an education standpoint to try to teach them 8th grade reading. So they pre-test everybody as they come in and find out that he's at the 3rd grade level. So they work to start where he left off at the 3rd grade level and bring him up to whatever level it can get. So let's say they move him up 2 years to 5th grade level, and he's mastered 5th grade level. When he takes these required tests, he's not tested at the level that he has mastered. He's tested at age-appropriate grade level, which would be 8th grade. And that's a disservice to these children and a major flaw with respect to the determination in finding a failure, because he's not qualified or has the ability to do 8th grade. So the school is not only being punished itself for supposedly not providing an appropriate education or making the extension to them and qualifying them from an education, but
let me ask you about this argument, and specifically the ALJ's findings that were adopted by the board. And I'm looking at paragraph 26, where the ALJ discusses this very argument you're making, that the school's failing academic performance was a result of its enrollment of students 1 or more years below grade level. However, the board's academic performance framework accounts for academic growth of students within any school year, and then the ALJ also goes on to say that the framework is designed to take into account how well the schools perform in catching students up, and compares students who are below age-appropriate grade level to similarly situated students. So, you know, we as an appellate court don't reweigh the evidence to determine whether we would reach the same conclusion, but isn't there evidence in the record from which a trier of fact could reach that conclusion?
Well, obviously he reached it. Was there appropriate evidence and the probative value of the evidence? While they made that, both the ALJ and the founding and the State Board for Charter Schools made that decision, it completely disregarded 3 finding of facts that were in there from a report that was submitted, which are found in findings of facts, I believe it's 108, 109, and 110, that basically set out the a study that found that the test itself had a bias.
Well, the ALJ did consider that and cited that as a factor that was presented at the hearing, but weighed the evidence and looked at things like this chart that shows that the school was compared to other similarly, the school's population was considered in contrast to similarly situated schools, and that some charter schools with even a higher percentage of, I think, free lunch students achieved A grades. So that the ALJ did weigh all of that. She just didn't weigh it in the fashion that you advocated. So how do we as an appellate court, when we don't reweigh evidence, do what you're suggesting?
Well, in the record, there's aside from the fact that the study showed that students in a free and reduced lunch have a tendency to be lower scores, which could change the school score by up to 2 grades. The comparison of the students is a difficult situation, especially when you're dealing with the students that are more, that are behind from a grade level, and special education students. Now, I have asked numerous times and have never received a decision as to how you compare special education students. You could have 2 special education students that are making the same grade. One could be a mentally developmental problem, which means that child is going to increase possibly, but he's not going to increase at a huge extent. The other one could be a special education student who has the same grade and is not having a mental cognitive problem, but has an Asperger's or one of the other ones that are more of a physical type of nature. Now, the next year, the odds are that the child with the more of the physical developmental issue is going to score higher, just inherently, regardless of what school it's in, regardless of where it comes from. In the record, when I asked the executive director, what school are those A schools, she couldn't remember. Now, I would think that that's something that would be pretty vital when you're talking about a school that you're challenging, and there's going to be a challenge directly to the, to those scores.
Let me-
Counsel,
oh,
go ahead. Let me follow up on the other questions, though, and I understand your perspective that there was contrary evidence. But again, we sit as an appellate court, and the question is, could another conclusion have been, is not whether another conclusion could have been supported. The question is, was this conclusion either an abuse of discretion or legally incorrect? So I understand your argument that there was conflicting evidence, but that's not what we're here to decide.
Right. And that goes back to the delegation to the superintendent. The superintendent would have been the one that provided more than just the raw scores of the test, but would have looked at the performance framework, and based on that would have made a recommendation over and above the A through F to the school, and also would have been able to utilize the remediation remedies that are found in Section 241, and 01 and 02. And the ALJ basically just took for gospel that all the computations were correct, and he even made a finding that the parents, there were no support from the, one finding said that there was tremendous support from the parents, which there is in this particular school. But in answering that question as, can there be two different versions? There obviously, consensus that there can be, but if it had been delegated to the superintendent, the superintendent could have given better and more conclusive results as opposed to just the opinion of the staff, and the staff's opinion as to whether or not they had the appropriate means to their progress reports to determine whether or not they were progressing or had something in place to progress. And that is where the State Department of Ed, through the superintendent, has the quality, has the abilities. They have specialists. They would send an improvement team consisting of the specialists of education, all the other means in there, where in this case it was just the staff.
But it sounds like your quarrel is with the statutes. I mean, the statutes authorize the board to do exactly what it did. We talked about 183I3A, but also 15183R vests the board with oversight and administrative responsibility for the charter schools it sponsors, and requires the board to ground its actions in evidence of the charter holder's performance in accordance with performance frameworks adopted by the sponsor. And so the board did exactly what the statute authorized it to do, but it sounds like you would prefer to see those duties vested in the superintendent, which is a legislative fix, not an appellate court fix.
But it's in the legislature. It doesn't say may delegate. It says shall delegate.
Looking at the very general, broad delegation of policy, but I'm looking at a specific authorization for the board to do exactly what it did in revoking and in establishing the framework. And so those are very specific delegations of authority that would trump this general policy delegation.
But the benchmark that they use is not like a normal set benchmark. It's free flow. It changes every year because it's based on the tests as the state as a whole, and what the state board is really looking for is the charter schools to all students be in the top 50%, which means there's going to be 50% below that. And I understand the goal of the State Board for Charter Schools wanting to have our state be one of the best with the best scores around. But the reality is we have charter schools that have students that are not going to achieve that goal up there. But they are moving the kids, and that's the key part that I think that they're missing. They're trying to create, in a school system that is created to be different, they're trying to uniformly apply criteria at a certain level, and not looking at the school itself and the students themselves. They're the ones that are being hurt in this deal. Because if we score, many of these kids have come from the regular district schools. That's where they would go back to if the school was closed. In that district, and I'm going to cut here in just a minute.
No, it's your time,
Yeah,
but I just
yeah.
don't want you to
And I still want to have some rebuttal. So, in a normal situation, I mean, these kids were kids that were bullied. You saw the testimony. They were bullied in school. A couple of them even to the extent that they actually thought about suicide. When they came to this school, the way that they teach changed that whole philosophy. They created self-esteem, and they learned. And that's the most important part. They learned. And the other two criteria, I think it's clear cut. We're only closing the school because it didn't meet the benchmark that was arbitrarily set by the State Board for Charter Schools. So I'll reserve the rest of my time. Thank you.
May it please the court, my name is Kim Anderson, and Assistant Attorney General, and I'm here on behalf of the Arizona State Board for Charter Schools. This case concerns the statutory authority of the Arizona State Board for Charter Schools to execute its academic performance framework to revoke the charter of a failing school. Appellant is confused about the law, appellant has not met its burden, and deference is owed to the decision of the Charter Board. In its interpretation of 15182E7, appellant ignores the principles of statutory construction. The provision of 15182E7 that the board delegate to the superintendent of public instruction its policies must be interpreted by reference to the system of related statutes of which it forms a part. That system of related statutes provides authority and responsibility to the Arizona State Board as the Arizona State Board for Charter Schools and as a charter school sponsor. Under 15182E and F, as the Arizona State Board for Charter Schools, it must exercise general supervision over the charter schools that it sponsors. It must determine the policy and the work that it will undertake. It must prepare a budget to accomplish its purpose and employ staff for its work. Under 15183R, as a charter school sponsor, in exercising its administrative and oversight responsibility for the charter schools that it sponsors, the charter sponsor must ground its actions in evidence of a performance framework adopted by the sponsor. And that performance framework must include the academic performance expectations of its charter schools and the measure of sufficient progress toward those academic performance expectations. Also,
forgive me, but then 182E7 and the delegation. So what is the practical effect of that? I mean, in the real world, that delegation causes the superintendent to do what in this context? What does the superintendent do then?
Your Honor, that the specific question really in this case is not what does 15182E7 provide for the superintendent to do, but rather, does the charter board have the authority to execute its academic performance framework? And what the legislature intended by 15182E7 is not the focus, but rather...
I understand that. My question is still, nevertheless, under E7, what does that practically mean? What does the charter board do pursuant to that, or that delegation? What does the superintendent do?
Well, there are statutes within the charter school statutes that do provide some duties for the superintendent of public instruction with regard to whether there is a violation of the Federal Education Privacy Act and with regard to whether a school is teaching contrary to the law. But in this case, as Judge Downey noted, we do have specific authority provided to the Arizona State Board for Charter Schools for its academic performance framework.
And the superintendent is a member of the board, correct?
Yes, Your Honor.
And the superintendent has not taken the position that she is entitled to do these things instead of the board itself?
No, Your Honor. Also, under 15183I3, the charter school sponsor must use its performance framework in conducting its 5-year interval reviews. and a school's failure to meet or to make sufficient progress toward the academic performance expectations in the framework provide a basis for the sponsor to revoke the charter of a school. Appellant argues in support of its interpretation statutory intent. On page 18 of its substitute brief, appellant states, "The legislature clearly intended for the academic performance framework to be executed by personnel under the control of the superintendent of public instruction." Appellant provides absolutely no legal authority for this statement. Also in support of its interpretation, appellant argues the charter board doesn't have the staff to monitor its schools. Again, appellant fails to provide any support in the record for that statement. In fact, to the contrary, it was the testimony of the executive director and the charter school staff that their responsibilities include monitoring the academic performance of the charter schools sponsored by the board. The legislature specifically tells the charter board, develop an academic performance framework, give charter holders notice of its contents, of its academic performance expectations, and what it will consider sufficient progress toward those academic performance expectations. In delineating the superintendent of public instruction's duties under 15241 and 15251, the legislature never gives the superintendent of public instruction any responsibility with regard to anything having to do with the performance framework, the charter board's expectations, or progress toward those expectations. And in fact, under 15241, if a charter school is assigned a letter grade of F, it is the charter school sponsor that takes action to restore the charter school to acceptable performance or revoke the charter.
That's the statute that I believe places the duty on the department to notify the board of the failing grade, correct?
Yes,
And then the board assumes the responsibility for moving forward under the statute.
Yes,
Is that
Your
right?
Honor. There is no valid argument that the legislature intended for the charter board to simply establish its performance framework and expectations, and the superintendent is supposed to execute it. Appellant also argues that the charter board failed to consider the purpose and scope of charter schools in its decision. Provide a learning environment that improves pupil achievement, provide additional academic choices for parents and students, and provide an alternative to traditional public schools. Founding Fathers has no evidence and provides no record reference in support of this statement that the charter board failed to take into consideration these purposes when it revoked Founding Fathers' charter. Nor does Founding Fathers address the overwhelming evidence to the contrary that is in the record and is in the answering brief. Founding Fathers' performance under the board's academic performance framework demonstrated that it failed to provide a learning environment that improves pupil achievement. Its performance under the dashboard, in the academic dashboard, in 2012, Founding Fathers did not meet the board's academic expectations. In 2013, Founding Fathers fell far below the board's academic expectations.
Is this the dashboard?
Yes, Your Honor. And under the Department of Education's letter grade system, Founding Fathers was assigned a letter grade of F. A school is assigned a letter grade of F after 3 consecutive letter grades of D. Founding Fathers was provided ample opportunity through the demonstration of a sufficient process to demonstrate academic success with its students. It was not tied to the results of the statewide assessment. The records show that there were a variety of student assessments that Founding Fathers provided to its students, but no evidence that it uses or analyzes or monitors that data from those assessments, or that the data demonstrates academic success with students, or such that Jefferson Academy is moving forward toward the board's academic performance expectations. In terms of additional academic choice for parents and students and an alternative to traditional public schools, there were a multitude of findings of fact that reflected the board's consideration of parent letters, student letters, parent surveys, student surveys, parent testimony, and student testimony. Appellant also argues that the academic performance framework deprived Jefferson Academy of assistance it could have received under 15241, and there is no evidence for this statement. Founding Fathers, in fact, assigns obligations to the Charter Board under 15241 that it does not, in fact, have. Appellant states that the Charter Board had a duty to consult with the Arizona Department of Education after it was informed of Jefferson Academy's F. That is not required under 15241. Appellant also states that in considering whether to restore a charter school or to revoke an F school, the Charter Board must first consult with the Department of Education for suggestions or assistance. And it was the testimony of the executive director that the Department of Education dictates when and how it provides services or intervenes in a school's improvement process, that it is not subject to or dependent upon the determination of the Charter Board.
I'm not sure I understood that last point, because the statutory options available to the board upon receipt of the failing notification was either revoking the charter or restoring the charter to acceptable performance. I'm not sure. Is that what you were just talking about, that second prong, or?
There were,
I understood your last point.
Your Honor, there were duties that appellant was assigning to the Charter Board under 241 it does not have, meaning that before the Charter Board could revoke the charter, that it was required to request
Coordinate with the
assistance from the
department,
Department
correct.
of Education.
Okay.
Founding Fathers also makes quite a few statements regarding the population of the students at Jefferson Academy. In its substitute brief at page 9, appellant argues or states that 30% of Founding Fathers students are eligible for special education services, but provides absolutely no reference to the record for this statement. And Founding Fathers also makes the statement that over 60% of the school students receive free and reduced lunch. Again, Founding Fathers provides no record references for this statement. In its substitute,
Are the statements incorrect then?
yes.
So the record actually reflects a different percentage?
No, Your Honor. The record reflects that there is no evidence with regard to the percentage of free and reduced lunch students at the school. Mm-hmm. And while in its substitute brief on page 9, appellant cites to two record references after that statement, neither one of them, in fact, support that statement.
And counsel, just to clarify, so the record's silent on that point from your perspective?
Yes. In any event, it was the testimony of the executive director that there are charter schools sponsored by the Charter Board that have a free and reduced lunch population in excess of 70% that meet the board's academic performance expectations and have received an A under the Department of Education's letter grade system.
I want to focus on one of the arguments Mr. Condos made that the ALJ addressed, and the ALJ and the board ultimately found that the framework accounts for the school's population of students coming from poverty and students with disabilities in its FRL and SPED subgroup proficiency comparisons. And I assume, well, I recall there was some testimony about how students are compared in the different subgroups, ELL, FRL, and SPED, but can you just remind us whether it is a true apples-to-apples comparison when you're looking at those subgroups?
Yes, the proficiency portion of the academic performance framework looks at, compares for these individual populations. It breaks out the individual populations, and it compares the average performance of students who are within those categories, each of those categories, to the performance of those students in those same grade levels to that same number of students, compares their performance to the state performance of those students in those same grade levels. Appellant also has stated on oral argument that There are students that are between 1 to 8 years behind grade level when they first enroll in the school. And while Founding Fathers states to Janice Stewart for this statement in its substitute brief at page 9, it provides no reference to the record for this statement. And in fact, the testimony contradicts this statement. There was the testimony of Carrie Pettit, who teaches a combined third, fourth grade. Her testimony was, most of my third graders, especially in math, are excelling. They're at the point where they can be taught at a fourth grade level with the core curriculum. She also testified that there are lots of students in her class that are above grade level and doing fourth and fifth grade level assessments. There's also the testimony of Sheena Mars, who teaches a second, third grade combined classroom. She testified that pretty much all of her second grade graders are performing at grade level.
Counsel, was that testimony from your perspective when they entered the school or after they'd been at the school?
There was testimony that some of the students, Ms. Stewart testified.
And just so you're clear, just those two examples that you provided that I'm asking about.
I'm sorry, Your Honor.
It's just those two examples that you mentioned that I'm asking about.
Oh, whether those students had come into the school that way?
Right.
There was no testimony with regard to, I don't believe there was any testimony with regard to how long those students had been at the school, but there was testimony by Janice Stewart that many of the students she has in 7th and 8th grade have been with the school since they were in kindergarten.
Got it.
I see that I have a few minutes left. Would the panel like me to address the board's motion to strike the arguments presented for the first time in appellant's reply brief?
I don't think you need to do that.
Your Honor, if you have no further questions.
The only other question I have is, as I recall the procedural history, Judge McLennan initially granted a stay of the revocation decision. It was lifted when the case came up on appeal, but then a motions panel reinstated the stay, which is in effect today, and depending on our ruling, either will stay in effect or be vacated. I don't remember if you asked us to take action on that, but we need to say one way or the other on that stay issue, don't we?
Yes, Your Honor. The court did grant a stay at the beginning of this case. Thank you.
Thank you.
When the question came up with respect to the superintendent as to what his obligation or the obligation of superintendent to do, there are 250 sections of the statute that apply to charter schools, even though they have their exemption from most of the educational statutes. With the exception of this one point, the Department of Education handles all violations, all investigations, et cetera, with that, and then they relay that to the charter school board to decide if any action should occur.
When you say, sir, with the exception of this one point,
The performance matrix.
that is the only, it's not really the power, it's the task, I'll put it that way. The task, you're saying that is the only task that the board retains? Everything else they really do delegate to the superintendent?
They get reports back from the superintendent as to whether or not there's a violation, and then they decide to either bring the board in. But there's a remedial plan in their policies, including the policy here with the academic performance, that sets out certain things, and there's a remedial aspect to it. What are you doing? This is what's been found. What are you doing? What are you going to do in the future to correct this particular problem? And while the superintendent sits on the board, it's only basically about 9% of any voting power, and there's not a lot of participation. But the key in this particular situation is the basis for revocation is solely the grade. And that test was
But the record established that was 5% of the decision. So what can you point to in the record that says the test was the sole basis for the revocation decision? Because I could not find that anywhere in the record.
okay. The charter schools were created for three primary reasons.
I'm just asking you, in the record, where can I find that the sole basis for the revocation decision was the test scores? Because what I saw was that it was 5% of the decision.
Well, if you look at the testimony of the school that was put together, Mr. Stewart's, Mrs. Stewart's, the
It
teachers.
couldn't tell you the revocation decision. I'm talking about what shows that the board relied solely on the test scores for revoking.
Because number one, they disregard the parents' decisions, the parents' opinions. The record has letters from parents, a number of them. There's a survey that was taken. There was every person who testified said that the school was making positive advances with their child's education. There was...
That's fine, thank you.
Okay. Just to make a point, Judge, there was nothing adverse from any parent in this particular matter showing preference, non-preference by a parent.
Mr. Condos, please wrap up, because we have another argument here.
Yes, ma'am.
Just take a moment and wrap up, though.
Okay. The other point that the alternative school, there was nothing in there except for the fact that there are district schools in the area. But the testimony of the parents was that most of these kids came from that other district school. And so this is clearly established as an alternative. And then the learning environment was focused by this board on the test. You know, there's much more to a learning environment than just a test. Are the kids safe? Are the teachers participating? Are there other challenges to it to make the school something they like? And every one of these children like to go to school where they didn't like it before. And that's the group that you really have to look to, the children. The testimony all showed by the teachers that they were advancing and increasing. By the parents, they were advancing and increasing. Not to the arbitrary standard created by the State Board for Charter School, but they were advancing and in that learning environment. And so with those three keys, I believe you had to have more than just the test to revoke it. Thank you.
I'd like to thank counsel for their argument today and their briefing on appeal. We'll take this matter under advisement and issue a decision in due course. We're going to stand at recess so that the bailiff can set the courtroom up for the next argument. Thank you very much.